President Trump recently tweeted claiming that former President Obama wiretapped him during his campaign. One can only imagine how nuts the media would have gone if the roles had been reversed, President Trump wiretapping either Obama or the Clintons, though his DOJ could have authority to do just that given the expansive leaks of intelligence information by Obama and Clinton supporters the last few months. Heck, he could wiretap the media at this point, legally and legitimately, as the sources of these unlawful leaks, for which Obama himself set precedent. Do liberals understand what Pandora's box Obama opened up by Obama using the powers of the NSA, CIA and FBI to spy on his political opponents? Even Nixon never did that. If the stories are correct, Obama or his officials might even face prosecution. But, we are still early in all of this and there are a lot of rumors flying around, so the key is if the reports are accurate. We just don't know at this time. The stories currently are threefold. First, that Obama's team tried to get a warrant from a regular, Article 3 federal court on Trump, and was told no by someone along the way, maybe the FBI, as the evidence was that weak or non-existent. Second, Obama's team then tried to circumvent the federal judiciary's independent role by trying to mislabel the issue one of foreign agents, and tried to obtain a warrant from the Foreign Intelligence Surveillance Act courts, and were again turned down, when the court saw Trump named, an extremely rare act of FISA court refusal of the government, suggesting the evidence was truly non-existent against Trump. And so, third, Obama circumvented both the regular command of the FBI and the regularly appointed federal courts, by placing the entire case as a FISA case, and apparently under Sally Yates at DOJ, as a foreign case, and then omitted Trump's name from a surveillance warrant submitted to the FISA court, which the FISA court unwittingly granted, which Obama then misused to spy on Trump and many connected to Trump. Are these allegations true? We don't know yet, but if any part of them are, then Obama and all his officials could face serious trouble. Can a president be charged with a crime? Only once out of office. While in office, impeachment remains the exclusive remedy in order to avoid a single judicial branch trying to overturn an election, such as a grand jury in any part of the country could. Once out of office, a president remains immune from civil liability for his duties while president, under a 1982 decision of the United States Supreme Court. However, as the Nixon pardon attests, nothing forecloses a criminal prosecution of the president after his presidency is complete for crimes against the country. Obama, the constitutional lawyer, should know that. What crimes could have been committed? Ironically, for Democrats falsely accusing Attorney General Sessions, perjury and conspiracy to commit perjury, as well as intentional violations of FISA. Rather shockingly, no law currently forbids misusing the power of the presidency to spy on one's adversaries. What the law does forbid is lying to any judicial officer to obtain any means of surveillance. What the law does forbid, under criminal penalty, is the misuse of FISA. Both derive from the protections of the Fourth Amendment itself. Under Section 1809, FISA makes it a crime for anyone to either engage in electronic surveillance under color of law under FISA without following the law's restrictions, or disclose, or use information gathered from it in contravention of the statute's sharp constrictions. FISA 50 U.S.C. is a very limited method of obtaining surveillance authority. The reason for its strict limits is that FISA evades the regular federal court process, by not allowing regularly, constitutionally appointed federal judges and their magistrates to authorize surveillance the Fourth Amendment would otherwise forbid. Instead, the Chief Justice handpicks the FISA court members, who have shown an exceptional deference to the executive branch. This is because FISA court members trust the government is only bringing them surveillance about pending terror attacks or grave hostile warlike attacks, as the FISA statute limits itself to. Thus, a FISA application can only be used in very limited circumstances. One important reminder about electronic surveillance. Occasionally, a law enforcement officer will hear or see or record information not allowed by the warrant, but incidental or accidental to otherwise lawful surveillance. Their job is to immediately stop listening, stop recording, and to delete such information. This is what you occasionally see in films where the agent in the van hears the conversation turn away from something criminal to a personal discussion, and the agent then turns off the listening device and stops the recording. Such films simply recognize long-standing legal practice. FISA can only be used for foreign intelligence information. Now that sounds broad, but is in fact very limited under the law. The only foreign intelligence information allowed as a basis for surveillance is information necessary to protect the United States against actual or potential grave hostile attack, warlike sabotage or international terror. Second, it can only be used to eavesdrop on conversations where the parties to the conversation are a foreign power or an agent of a foreign power. An agent of a foreign power cannot be a United States person unless they are knowingly involved in criminal espionage. No warrant is allowed on that person unless a FISA court finds probable cause the United States person is knowingly engaged in criminal espionage. Even then, if it involves a United States person, special steps must be taken to minimize the acquisition and retention, and prohibit the dissemination, of non-publicly available information concerning unconsenting United States persons. This includes procedures that require they never identify the person, or the conversation, being surveilled, to the public where that information is not evidence of a particular crime. Third, the kind of information sought concerns solely information about a pending or actual attack on the country. That is why the law limits itself to sabotage incidents involving war, not any form or kind of sabotage, explicitly limiting itself to those acts identified in Section 105 of Title 18 of the United States Code. This brings us to Watergate on steroids, or #Obamagate. Here are the problematic aspects of the Obama surveillance on Trump's team, and on Trump himself. First, it is not apparent FISA could ever be invoked. Second, it is possible Obama's team may have perjured themselves before the FISA court by withholding material information essential to the FISA court's willingness to permit the government surveillance. Third, it could be that Obama's team illegally disseminated and disclosed FISA information in direct violation of the statute precisely prohibiting such dissemination and disclosure. FISA prohibits, under criminal penalty, Obama's team from doing any of the three. At the outset, the NSA should have never been involved in a domestic U.S. election. Investigating the election, or any hacking of the DNC or the phishing of Podesta's emails, would not be a FISA matter. It does not fit the definition of war sabotage or a grave hostile warlike attack on the United States, as constrictively covered by FISA. It is your run-of-the-mill hacking case covered by existing United States laws that require use of the regular departments of the FBI, Department of Justice, and constitutionally Senate-appointed federal district court judges, and their appointed magistrates, not secretive, deferential FISA courts. Out of 35,000-plus requests for surveillance, the FISA court has only ever rejected a whopping 12. Apparently, according to published reports, you can add one more to that. Even the FISA court first rejected Obama's request to spy on Trump's team under the guise of an investigation into foreign agents of a pending war attack. Intelligence agents apparently returned to the court, where, it is my assumption, that they did not disclose or divulge all material facts to the court when seeking the surveillance the second time around, some of which they would later wrongfully disseminate and distribute to the public. By itself, misuse of FISA procedures to obtain surveillance is itself a crime. This raises the second problem, Obama's team's submission of an affidavit to the FISA court. An application for a warrant of any kind requires an affidavit, and that affidavit may not omit material factors. A fact is material if it could have the possible impact of impacting the judicial officer deciding whether to authorize the warrant. Such affidavits are the most carefully drawn up, reviewed, and approved affidavits of law enforcement in our system precisely because they must be fully disclosing, forthcoming, and include any information a judge must know to decide whether to allow our government to spy on its own. My assumption would be that intelligence officials were trying to investigate hacking of DNC, which is not even a FISA-covered crime, so therefore serious questions arise about what Obama administration attorneys said to the FISA court to even consider the application. If the claim was financial ties to Russia, then Obama knew he had no basis to use FISA at all. Since Trump was the obvious target, the alleged failure to disclose his name in the second application could be a serious and severe violation of the obligation to disclose all material facts. Lastly, given the later behavior, it is evident any promise in the affidavit to protect the surveilled information from ever being sourced or disseminated was a false promise, intended to induce the illicit surveillance. This is criminalized both by federal perjury statutes, conspiracy statutes, and the FISA criminal laws themselves. That raises the third problem. It seems the FISA compelled protocols for precluding the dissemination of the information were violated, and that Obama's team issued orders to achieve precisely what the law forbids, if published reports are true about the administration sharing the surveilled information far and wide to promote unlawful leaks to the press. This, too, would be its own crime, as it brings back the ghost of Hillary's emails. By definition, FISA information is strictly confidential, or it's information that never should have been gathered. FISA strictly segregates its surveilled information into two categories: highly confidential information of the most serious of crimes involving foreign acts of war. Or, if not that, then information that should never have been gathered, should be immediately deleted, and never sourced nor disseminated. It cannot be both. Recognizing this information did not fit FISA meant having to delete it and destroy it. According to published reports, Obama's team did the opposite: order it preserved, ordered the NSA to search it, keep it, and share it. And then Obama's Attorney General issued an order to allow broader sharing of information and, according to the New York Times, Obama aides acted to label the Trump information at a lower level of classification for massive-level sharing of the information. The problem for Obama is simple: if it could fit a lower level of classification, then it had to be deleted and destroyed, not disseminated and distributed, under crystal-clear FISA law. Obama's team's admission it could be classified lower, yet taking actions to ensure its broadest distribution, could even put Obama smack middle of the biggest unlawful surveillance and political opponent smear campaign since Nixon. Except even Nixon didn't use the FBI and NSA for his dirty tricks. Watergate would have never happened if Nixon felt like he could just ask the FBI or NSA to tape the calls. This is Hoover-esque abuses of the kind Bob Woodward Powell, former FBI Assistant Director Mark Felt, otherwise known as Deep Throat, routinely engaged in at the FBI until convicted and removed from office. You didn't know that Deep Throat was really a corrupt part of Deep State, did you? Guess who ran the famous COINTELPRO? That's right, Deep Throat. How would the public have reacted if they knew the media had been in bed with the Deep State all the way back then? Maybe that was the reason Woodward, Bernstein and Bradley kept Deep Throat's identity secret all those years? Democrats may regret Sessions' recusal, as his replacement is a mini Sessions, a long-respected, apolitical, highly ethical prosecutor, Dana Boent, whose reputation is well warranted from his service at the tax division, and who won't be limited by any perceived ties to Trump. given his prior appointment by Obama. Obama himself appeared scared of Boehner, as he removed Boehner from the successor to Sessions position during the lame duck part of Obama's presidency, but Trump restored Boehner to that role earlier this month. Democrats may get the investigation they wanted, but it may be their own that end up named in the indictment. Law News helped contribute to this story. Its news exposed signing off